wonderful. That's what it looks like actually. So we have a lot of wonderful articles there for people in terms of reference, legal writing, what's like how to write a good clause, and we've also got some online courses. We've got a lot of things actually. So if you're interested into legal writing and you really want to take this up, this is a good resource and a very good starting point. So usually it's always good to begin with a quote just so that it frames our discussion to some extent. And it's a quote from John F. Kennedy actually. So it says that oops, sorry about that. It says, "Let us never negotiate out of fear, but let us never fear to negotiate." So I'll give you a couple of seconds, maybe just to sort of absorb that quote. Where I think what he's trying to get a sense of saying that whenever you're negotiating, don't come from a position of fear. And I think as lawyers, this does resonate to a certain extent, because sometimes we're representing a party that is not the sort of equal in the relationship, and we ourselves can have that fear when we're going into a negotiation. But I think what he's trying to say is that don't have that fear. Let you have to do it anyway, and if you're doing it, then just do it from a position where you're in a commanding position and not necessarily in a position of fear. So at least that's what I understood. Be happy to hear from anybody else if they have any different thoughts, or if they think differently. So yes, let's go into the steps to a good legal negotiation. But maybe just let's take a step back and just ask ourselves, why is negotiation important? I mean, what is it about a good negotiation that actually helps you? Why is this an important thing? Oh, I see somebody is trying to chat. Oh, okay, yeah, thanks. These are the messages coming in. Okay. So yeah, a good negotiation is actually, I mean, more so as a lawyer and the experiences that we have, it is very important. But even in our daily lives, we have seen that negotiations can actually help us build better relationships, because when we're negotiating, we actually come to know more about that particular person, or we come to know more about where they're coming from, in a sense. In some way, negotiation can also end a relationship, where sometimes a very brutal negotiation or some sort of misalignment on a particular position can then just have two parties completely walking away from a relationship. But that's kind of not the point here. The point is for all of us to understand the importance of negotiation, and also maybe where we can actually further a relationship, not actually end that. So yes, that's the first point. Helps you build better relationships, helps you deliver long-lasting quality solutions, especially if you're working with the same party. Like in my current role, since I'm a legal counsel, we engage a lot of service providers, and sometimes it's the same service provider, and sometimes there'll be a negotiation on. Usually, it's always on the payments clause, or in terms of the method of payment, or how many tranches, or sometimes even the limitation of liability. And having sorry, was it somebody saying something? Okay. Yeah, so sometimes knowing better or knowing more about that particular party can then help me in another subsequent negotiation, because I've actually learned something from the first one, and then I go into that second one already with all that information in my mind. So it can help you even avoid potential conflicts and misunderstanding. So let's talk a little about, yeah, everyday negotiation, which is, I think, is as Indians, we have seen negotiation in very different scenarios, right? We've seen negotiations at the local fruit and vegetable market. So you might have actually experienced, maybe when you're actually going and buying something, you might have experienced people negotiating or haggling, or when you're trying to buy maybe a secondhand product. So negotiation pops up and crops up in scenarios where perhaps it's most unexpected. And we do develop some maybe some preconceived notions about how we operate, but usually it's best to have some sort of strategy before you go into the negotiation. So maybe when you're with friends, you might be negotiating about whether to order a pizza, or whether to go to watch a particular movie, Or most of us, if we've had at least one job, we have realized that maybe there was a salary that we negotiated for, or perhaps there was no negotiation at all, and maybe even that was a cause for concern. So the point simply is that negotiation is even present outside the legal domain, and it's probably good to have a sort of normal or a particular negotiation style where you kind of learn from it, and you can kind of move on and then maybe put some of those lessons into your legal negotiations. So I'll give you maybe about like 30 seconds or so just to imagine two or three different scenarios where you might have recently used a negotiation. And when you're thinking about that, just think about what were your primary aims in negotiating during that situation, or if there's more than one situation, did you see anything that was common or parallel in that? Actually, I'll give you a minute. I think there's a few people, maybe they're trying to enter the chat. So I'll just stop my sharing for a minute and I'll rejoin. And in the meantime, then maybe we'll get a chance to discuss what you've seen. Okay, and we're back. So, would anybody like to volunteer to sort of maybe share what they, the scenarios or basically what they learned about? You can just unmute yourself and speak. Anybody at all? Okay, so maybe I'll volunteer. That's okay. So I think recently as I'll just take an example from my own working life. So I think yes, I was telling you that we engage a lot of service providers, and what I always saw in that negotiation from a personal standpoint is that I always wanted to very initially I just wanted to avoid conflict because I wanted. That okay, there's this contract that's about to be signed, everything else is in place, it's just a matter of negotiating or getting a agreement on this last thing, so let me avoid a conflict on this. But when everything was done and I got a chance to reflect upon that, I realized that maybe I could have tried a different approach. I could have actually gone in trying to understand where they were really coming from, because all I was looking at was what they were saying, like the words coming out of their mouth. And I was like, okay, I don't want to make a mess of this. So let me just go ahead and, try to end the pain as soon as possible. But actually, from a negotiating perspective, as we'll, get into some detail in the later slides, maybe that's not the best approach, because while it's the most practical approach in the in the circumstances when you're trying to close out a contract, it also does deprive you of the opportunity to really understand where the other party or other service provider or entity is coming from, which is kind of the point of a negotiation, the back and forth. So if you found yourself trying to avoid some conflict or trying to avoid an unnecessary discussion, it could have been a missed opportunity, or perhaps it was just a way for you to get things done sort of quickly. Right. Let's move on to the next one. Okay, I don't know what's going on here. Okay, yes. So the goals of legal negotiation, the first one, as I was just mentioning, is to arrive at a compromise in settling a dispute in a way that is most beneficial to the client. So you want to achieve the best possible outcome, ideally without the need to resort to a court or an arbitrator or some sort of litigation. So the first is to arrive at a compromise, but at the same time, that's beneficial to your own client. Then it is to achieve the best possible outcome, and nobody ends up in court, hopefully, because of that. And the third part is what I was talking about earlier, is that you get to know where where that other person is coming from. So you also obtain a lot of information, which can be helpful if you're signing other contracts or doing other kinds of work with that entity in question. So how do you get into that detail? What is, should we just focus on the words coming out of somebody's mouth, or how do we, or perhaps over email? And I think what the negotiation gurus say is that don't just focus on the position, go behind the position, or however you understand, under the position, and see what that underlying interest is. So sometimes you'll have interests that are disclosed, or sometimes people will say things, but there's some other interest, like maybe the service provider wanted to be paid in lesser tranches, or they wanted to be paid more, but they can't say that directly. So they'll hide their interest, and they'll only tell you one particular thing. Or maybe when you're signing up for a new job, and their position is to maybe hire you at the best deal possible, but they're never going to say that. So they'll say, well, we're only going to offer you. Sorry, could I request people who are, maybe if they could mute themselves? Right. Thank you. Thank you for that. Yes. So coming back to where I was, the slides just move back. Yeah, so basically, you'll always have people hiding behind a particular position. And the idea really is, when you're doing a negotiation, is to try and get them to get to that position where they can, where you can actually, sorry, the underlying interest, where they can actually expose that underlying interest, and then you actually understand, okay, here's where they're really 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 coming from. So the interests are why the negotiators take the positions that they do. As I said, interests, they lie behind the positions, and they represent that basic need. That employer that wants to get you at that best deal possible. That big company that you're signing a contract with, that has thousands of service providers like yourself, and they don't even care. You're just like one amongst any. So go behind that. And also you might see that it also helps you understand what is sort of the equality in the relationship, who has more bargaining power, who has less bargaining power. All of that will then affect what kind of negotiation style you adopt, because maybe if you work with them on a frequent basis, you'll go for a more like win-win kind of approach. If you don't know them too well, then that'll also then you can actually afford to be more aggressive, and take a slightly a more adversarial stance when you're negotiating. Let's take a minute or two just to talk about, you may have heard of this, you may not have heard of this. It's called BATNA. It's actually the best alternative to a negotiated agreement, and it can be different things in different situations. So if let's say your negotiation involves finalizing a deal, right? Like maybe you're looking for companies to engage with, and you want to sell, or you're looking for a particular service, but you don't want to pay more than a certain amount. So if you get a better deal somewhere, then the best alternative for you in that situation is to just walk to away to another party that can actually offer you a better deal. But if you're dealing with a termination clause in a very complicated kind of a contract, where it said that, okay, any issues, we agree to resolve them by access to a particular court, then if negotiations have failed, then perhaps the best alternative in that situation is actually to go to a court. So but keep this concept in mind, because sometimes when we're in a negotiation, we can just ask, okay, what's the best alternative here? Can we engage in a further negotiation? Do we walk away, or do we actually just end up in court? So the bottom line is actually the reservation price, or the position at which the deal is going to be completely off. So if it's a purchaser, then it's the highest price that the purchaser is willing to pay. If it's the seller, then it's just the lowest price that the seller is willing to sell the goods and services. So sometimes people will have like negotiation strategies, like it's called split the difference. There's actually a book also called Never Split the Difference. So there's some people who kind of, argue against that and say, no, that's not the best idea. But yeah, basically it's just a way for you to understand that, okay, the bottom line is that, like, that bottom reservation, after beyond which, it's the deal's just not going to go through. So things to think about. I think the way I have also been speaking, it gives you the impression that a negotiation is actually taking place between two entities or two parties. That's kind of the default framework that we take. But actually, believe it or not, negotiation can happen between multiple parties, like all on the same transaction or same contract. And that's when things can get a little more complicated, because then you have that many more positions, you have that many more interests, or you may still have only two positions, but you just have more people to deal with. So in some way, it's like a game of chess where every move will really, really count. So, I mean, this is not a forced exercise. It's a voluntary thing. People are there, in the room or over a call to get something out of that exercise. So just remember that every party or every person has that right to walk away or just to refuse to negotiate in the first place. So you might find that that happens with a lot of bigger companies, or perhaps when you are when you're going for an employment role where the salaries are, they have a market bandwidth that is already fixed. Okay, so let's do some pop quiz exercises. If a negotiation in India gets heated because of different objectives, avoid eye contact with your counterpart, since it could be read as aggressive and disrespectful. So I'll give you about a few seconds just to think about whether that's true or false. Would anybody like to maybe volunteer, take a sort of stab at this, a crack at this? You don't have to be right or wrong. It's just, we're just using this as, a way for you to understand how negotiation works. So do you think that avoiding eye contact, maybe that's a good idea because it could be aggressive or disrespectful? Um, Anybody at all? Okay, so, oh, did somebody say something in the chat? Okay, so actually it is false, because actually, on the contrary, making eye contact conveys sincerity in India, and it might actually help in this case. So yeah, it's not always that you have to avoid eye contact because you'll come across as aggressive or disrespectful. Okay, how about this? Oral commitments can represent legally binding contracts in Germany. So you think, yeah, sorry, somebody trying to say something? Okay, maybe it was just this thing. So yeah, oral commitments, do you think it represents a legally binding contract in Germany or not? I mean, is it true? Is it false? What do you think? Maybe I should start calling on people. I don't know. Sorry, are you saying something? Okay, so I So it's true actually, because even though proving an oral statement in court can be difficult, the legal risk may not be very high. So actually, most Germans and maybe many other parts of the world, you will actually be expected to kind of live up to the oral commitment that you're making. So just like that, Germany, whether you have a commitment in orally or in writing, you will expect it to be kept. Okay, let's try this one. So Venezuelans, they communicate quite directly. They will usually let you know right away if they don't like the terms and conditions of your proposal. So do you think that's true, or do you think that's false? I'm just going to stop the sharing for a second. Okay, so it's actually true. Venezuelans do tend to be more direct than other Latin Americans. So let's try the other one. Decision making in Ireland is often very quick, assuming you're dealing with the right person. So do you think that's true or do you think that's false? Well, actually, it's true because Irish organizations are really hierarchical. So you need to verify that you're actually talking to kind of the person that matters. And then if you do get to that person, decision making can be quite quick. Okay, so you can try this quiz if you want. You can. We won't actually be doing it today. We'll just use this the sort of the result that comes in to talk about negotiation styles. But yeah, actually, it will sort of help you understand what negotiation style you have or what kind of negotiator you are. But really, there's these many different ways that you have. So you have like a competitive negotiator where it's like I just want to win at all costs. It is an assertive approach, and usually it's when you don't know the party so well and you're kind of trying to just get your way through. Then there is the avoiding one, which is kind of what I had sort of spoken about earlier, where you just you want to avoid conflict, you want to have a painless exit, and you don't really worry about the details because you feel okay, everything else is sorted out. So that's when you're avoid. That's not the kind that I recommend always. I think where you want to be is in this zone, which is the cooperative, collaborative zone, where you're actually concerned about the other party's interest and you want to get the best deal for everyone. You actually work closely with them, you understand where their interests and positions lie. And also then it's collaborative in a way. If you're working with more than one person, maybe you could have a co-defendant or a co-counsel, and you're trying to understand how everybody is kind of aligned. There's also a few others where you can be principled, you can have you can be accommodating, where you're actually very sensitive. Sometimes there's a risk that you might end up compromising your own client's position, where if you end up being too accommodating. So you want to hesitate before you compromise entirely, and you want to make sure that you have at least put forward your basic idea that okay, this is what I, or your expectation. So don't perhaps the good idea not to compromise like very early in the negotiation. So, okay, let's talk a little about what are the different forms of negotiation. So, we have competitive and we have integrative. So competitive is, basically from the word itself, right? If you have no intention, you don't really care about, maintaining an amicable relationship, then your approach will be, okay, I'm going to be as competitive as I can. I'm just going to beat the opposition. I'm going to get what I want out of this. And even if that, if it works, it works. If it doesn't, it's fine. It's a very like all in high stakes, like my way or the highway kind of frame of mind. And I think you can do that when maybe you're a very big company and you have thousands of people vying for your business or vying to be with you, or maybe you're some big celebrity, or you're the lawyer for some big celebrity, and you know that there's so much demand for this person that okay, this is what it is, and I'm not even bothered that I'm going to see you next time. So it's a very predetermined position, and this is his whatever or her service, the services, the rate for the services, and that's it. But more often than not, you'll find that yeah. So these are the indicators where parties not know each other well, and it's usually very limited, price only, or they're unlikely to work together in the future. But often you'll find that it's actually the other approach that you need to adopt. But sometimes this can be helpful too. Just depends on who you're kind of dealing with or who you're dealing for. So maybe in your own mind, just identify three potential advantages and disadvantages of taking a competitive approach. And just think about, okay, is there a scenario where this will be really helpful for me, or would the three disadvantages, maybe what you can do is you can take a pen and paper and just have like a column and have advantages and disadvantages, and see if the column on the right hand side, which is ideally the disadvantage column, does that sort of outweigh what advantages you have, or maybe you feel, no, this is my style, this is what I'm good at. Then maybe that becomes your natural style, and you may have to move away from that in certain situations, as we've spoken about. So yeah, the advantages are basically that if the other side is very accommodating, you in likely is that you will get what you want from that equation. So also, because there's only one party is accommodating, one party has a predetermined position, chances are the situation will be resolved quickly. So your actions kind of force the other party into a situation where they just have to agree to your terms, or because the underlying context is such where, as I mentioned, the celebrity example, the big company example, where they just want to get your business, or they really want to have you on board, so they will bow down to your terms. So that's, if you're the competitive person that's representing the more powerful party, that's a good position to be in. On the other side, though, it can be difficult, but sometimes we will, in all of our careers, we will find that we will have both those situations. So it's not just one all the time. Some disadvantages are that obviously there is tension, there is mistrust. There's also a lot of if I can say, some sort of bullying that may happen, or the take it or leave it approach. So there's no mutual understanding, or there is very little sort of cooperation, collaboration that's happening. And also sometimes, if you are taking a competitive approach, and it's two very powerful companies, like maybe, I don't know, Pepsi or Coke, or some entities that are like really really strong, then the other one can also retaliate with an equally competitive position, and then all hopes of collaboration and cooperation are going to go out of the window. The settlement will become much harder to reach, because now you have that tension and mistrust that's there between the two parties. And you're wondering, okay, how do I put an end to this? So you have to be a little careful when you're dealing with two very powerful entities, is that, okay, maybe competitive negotiation can have this potential outcome in the near future. And so let's talk a little about what kind of tactics can you adopt. So you can have what we call as early anchoring, which is that you become the first party to make an offer that is beyond the fair margin or the range of credible or reasonable offers. So what happens is that it's like early anchoring. I have already set the price up so high, or I've already, whatever thing you're dealing with, it's already in a particular range. So it's like, okay, well, now we've already started with this. So if in case you have any fear that, I'm going to be lowballed, okay, let me take the first lead and just start with that. The other one is what we call as fainting, which is misleading the other party as to your true interests or objectives by stressing goals or interests that are, in fact, like unimportant to you. So you're kind of hiding what's really important for you. And then you come to know, because the other party might actually be honest, and they might actually say what they have in mind, what their underlying interest is. And then you're like, in your own mind, you're like, haha, got you. I know exactly where you're coming from, and now I'm going to try to maybe lowball you, or put in my real interest. It's interesting though, whenever I always think of that, is that if both parties are kind of doing that to each other, then who finally ends up speaking the truth? Like, it's something for you to think about. And often you'll have people misleading as well. Like you can have a misleading bottom line that's put across, or perhaps you can say, oh well, all right, we're happy with this, but actually you could have maybe gone a little higher or a little lower. So there's many ways when you're in that competitive space, because there's no end, or there's no where do you draw that line in the sand, because it's both parties are being absolutely competitive. So yeah, I was speaking earlier about splitting the difference. So maybe one easy way to understand this is actually in terms of dollar amounts, which is, if you're stuck at different positions, like somebody is saying no $600, the other one is saying $8,000. So sorry, $1,000. So the difference is $400. So you'll just literally go and like split whatever that $400 difference is. You'll just go at that 200 mark, and it's like, okay, you also got something, I also got something. So sometimes when we, I don't know, when we're younger, we're trying to buy things, and our parents are not really convinced, and we're like, okay, well, let me buy something middle, maybe it could have been an iPhone, or an iPad or anything like that, and so we go for the middle option. So sometimes people, they say that it gives the appearance of fairness. And using that same parental analogy, we also have some ultimatums, like take it or leave it. Okay, this is what I'm going to pay for. This is the university that I'll finance. So yeah, that also actually just prevents you, right? Because how do you now, when somebody has just thrown in the towel and said, okay, I'm not going to go beyond this, then it doesn't really help, because you are prevented from making an offer. And I actually, there's also another, like a variation of this ultimatum, which is the walk away. So I remember when I used to go with my mom to buy anything from like the secondhand market. She would actually quote a price and then just start walking in the opposite direction. I used to often wonder what exactly she's doing, and then I would see the kind of the shopkeepers coming right after her, like, madam this, madam that, and then typically the price would. And later, we actually, when we studied negotiation, I'm like, oh, so that's what it was all about. It is a very classic tactic in bazaars and markets, and it's actually a bluff, because you also know that the price is going to go down. The Probably the guy who's chasing you is also going to think, okay, okay, let me not lose the deal. But hey, it works. And maybe when you're walking away, you're like, okay, I need to think about what my alternative is. And then there's also the you will have to do better than that, which I think I've seen in salary negotiations quite a bit, where you get a salary, you're maybe not so happy, and you're thinking in your mind, okay, well, you have to do better than that, otherwise why would I leave this particular job or this particular industry. So, or maybe even if I had to talk about in LLM terms, scholarships, sometimes that can be an interesting negotiation point between you, one university, and another university, where you're like, okay, I already have X amount of scholarship, I don't know, 5,000, $10,000, something like that. And now that's like your reservation price, and you actually want the other university to at least do better than that. So, interesting situations where these things crop up. Okay, so let's talk a little. I think we've spoken and fleshed out comparative negotiation quite a bit. So let's talk about integrative negotiation, where both parties are actually trying to reach a mutually beneficial outcome. And so that approach then becomes integrative. So where each party is taking a very amicable approach, and the idea is to come up with a compromise that will, eventually like work for both sides. So the idea here is parties know each other. They are going to have some future interaction and further interactions. They don't want to lose that relationship that is there. So maybe when before we go into details, just like how we did for the previous one, just in your mind, or if you want, you can draw up a column. Identify three advantages and three disadvantages of taking I think that's a typo, it should be an integrative approach to negotiation. So just do that in your mind, and we'll kind of go through these slides just to see if you got close, or maybe this will help you think about it in the future. So clearly it's conciliatory, so therefore it creates a very good climate, and it's very conducive to like a healthy negotiation. Sometimes it can start off as in where both parties are being collaborative, and then suddenly somebody becomes competitive. I've seen that also. And then it's really up to either that opposing party, if there are more, or if there are like more negotiators in the room, then somebody brings it back to conciliatory. So it can shift as well. It's not that I just started with one approach and I'm going to continue all the way through. It can change depending on the perhaps the clause, or depending on the interests at stake. So if you do take an integrative approach, you will find some sort of comprobe or compromise position that is mutually beneficial, and that will really be more helpful in terms of maintaining the working relationships. And it'll also, if I can just tell you honestly, it'll give you less acidity, and also the other person, and it's a more friendly exchange rather than just everybody at each other's throat. But yes, there are some disadvantages. You can end up being way too accommodating. You can feel like you got the short end of the stick, or maybe I could have done this, I could have done that. It does leave you with some of those thoughts. It takes time, because if everybody's being accommodating and you're talking nicely, then you have to get to the real stuff also, and that process can take some time. And if you have a client that's there, or perhaps then you later you brief them about what you did, the client's like, well, you were too soft, we could have done much better. And so sometimes, yes, that can happen as well. So yeah, so as I said, focusing on interests, which is the why behind why people take positions, that will then help you understand, okay, what's the solution, where they, let me, let me go for what is really important to them. And in fact, sometimes, actually, if you see this movie, Up in the Air, I think George Clooney used to do that in that movie, where he would like go and say, okay, well, this is really important to you, right? So then he would go ahead and kind of, I think that's what he used to do in that movie, is that he would go when people are like being terminated. I don't know, it was really long ago that I saw the movie, but I just remember that. I'm like, wait, this is from that film, right? Yeah. So you can just say, okay, well, this is really important for you, right? And then kind of come and try to hit that middle ground. Another maybe other strategies, you can just expand the pie. So it's possible to brainstorm and increase the resources to be bargaining for. So maybe I can say this in my own consultancy, where perhaps people come and they want to have just one or two services, and I can be like, well, you know what, actually I can do all of this for you in whatever this much price. And so I actually just literally expanded the pie, and I'm like, okay, yeah, maybe that works for me. So this is one example. Or if you're buying you want a contract with like a telephone service provider, and you want a certain level of minutes, and maybe you also want international minutes, and you want like certain amount of GB, or yeah, and you're like, okay, well, maybe I could just go for this. So you can always expand the range of outcomes as well. And if you're the service provider, like how I am in my example, yeah, that works out great. Sometimes it can work backwards also, but let's not go into that. I think, yeah. So tactics, open information exchange. You're very honestly kind of admitting to what your objective is, what you actually want from this relationship. And if let's say there's another strategy called log rolling, where if there are two or more issues at dispute, then let's say you're arguing over maybe like a force majeure clause and a limitation of liability clause. And so the force majeure clause, even though there's a pandemic, they want the word omitted, and they are okay with the word epidemic. So like, okay, I'll agree to omit this, but I want my limitation of liability to be X. So it's like a trade-off. Okay, you give me this, I'll do that. Something like you scratch my back, or actually that's more quid pro quo. So let's not get into that. So yeah, log rolling could be one way. Or you can have more of like an objective criteria, where you just say, okay, this is what is fair. And it's like how in the earlier slides we talked about priming the discussion. So you set the benchmark up, and then it's like, okay, well, we're not really kind of going to go beyond this, or above this, or lower than this. So that kind of acts as a threshold. um, so yeah, as I said, these two positions are not necessarily mutually exclusive. Quite often, there will be a position that's kind of in between these two extreme ends, if I may say so. I have seen personally people starting off collaborative, and then on certain clauses they become really aggressive, and they're back to collaborative. I've also seen people just be really really aggressive, where you're just like, what is up with you, and why don't you just calm down? And they're like, no, this is how I am, this is what I'm good at. So there's all, because inevitably you bring a certain personality to the negotiation table, or the conference, or sometimes nowadays we're all working virtually. So yeah, it can be difficult to, maybe there's some egos also involved, but that's not for us to discuss. It's just about, okay, what's the best approach? Maybe it's a spectrum of approaches, and from time to time we can move from one end of the spectrum to the other, depending on what kind of goal or outcome we're trying to get. So yeah, this is basically a neat table. It's got a bunch of things. If you're more like if it's a short-term relationship, which one should you go for? Or if you're going for distributive, then the ability to make trade-offs not that great. So it's just a handy table summarizing what we've just spoken about. So maybe time for another pop quiz. Okay, so in Taiwan, it's strongly advisable to negotiate in a team rather than as an individual. So in the interest of time, I'll just I'll kind of move quickly through these. So actually, yes, negotiating in Taiwan, it's better to do it as a team, not as an individual, because if you're there as an individual, they might bring like a really skilled team of Taiwanese negotiators, and then you're easy pickings for them. Okay, so in Canada, do you think using English language material presentation is okay? Or would some Franco-Canadians, that's people whose native language is French or they're bilingual, and would some of them prefer to see it in French? So the answer is actually false because many Canadian companies may require material to be bilingual. And in Quebec, which is the French part of Canada, this may even be required by law. So I think this is the last one. Bringing a legal counselor to Italy to business negotiations, is it a good idea? Or is it that, because the country has a very complicated catalog of business laws, do you think it's a good idea or not? Because even your local counterparts will bring an attorney. And it turns out no, because they're very traditional and they may actually interpret this as a sign of mistrust on your side. Yeah. So, I mean, you can use these scenarios. This is like, what I kind of spoke about with the street and fruit and vegetable cart. So if maybe you're on a vacation, you're there with a street vendor, what kind of negotiation strategy would you do if you're buying a souvenir? Chances are I'm never going to meet that person again unless I go to that country every year for a vacation. So I can really be very aggressive and competitive, and I can be like, okay, I can even have a take it or leave it, because maybe there's many other guys or however ladies that are there with that particular souvenir. So negotiation strategy can be very different. I really like the second example a lot. A couple deciding to which movie to watch at the theater. One wants an action flick and the other wants a romantic comedy. So if this can go both ways. If you're in a relationship, or you are you have some prior experience, that it's never really one party all the time. It's always, in fact, if I can say so, a lot of time these days is spent actually deciding or negotiating over what to watch over Netflix and Amazon Prime. And so the negotiation strategy can be very different when you're going through that. But I'll leave it for you to figure out what's the best. And sometimes it can backfire also if you take a very aggressive stance.
Samarth, you prefer the romantic comedy, right?
Oh yeah, always, always. I'm always a romantic comedy person, but in my case, it's more that my significant other has always seen most of the movies. So I'm like, okay, what now? How it's more like, okay, how I'm like arguing against a wall. I'm like, okay, what do I now? You have to see it again with me. So that's why I said, well, I'll leave it up to you to decide. So yeah, a consumer. The last one is a consumer visiting a car dealership to buy a new car. Now that's a pretty significant investment, and you may have a lot of your interests. Like you want certain features, you want certain um, like service obligations, you want maybe the first whatever certain 1,000 kilometers taken care of, or warranty. So there you may actually want to have a more collaborative approach, because even the auto dealership or the car manufacturer, depending on who's selling it, they may also want your business, but at the same time you also have a laundry list of things, given because a car is, I mean, at least you would do a lot of research before buying that. So yeah, you might want to be more collaborative, and you actually want to have a good relationship with that dealership, or with the manufacturer, because they're going to be servicing your car for at least a few years. So yeah, all those things are pretty important, and will affect your negotiation style and strategy. So yeah, with that, we have come to an end. Have a great day, and I think I'll be doing the next one as well, where I'll get a chance to speak to everyone. If you have any questions or anybody has anything that they'd like to share, we have a few minutes, maybe on negotiation or anything at all. If you'd like to connect with one of us, you can just we can put our emails in the chat window, and you can sort of reach out to us for any questions on negotiations, legal writing, or even just LLM advisory work. I'll stop sharing and I will put my email, and I request Josh also to do the same. So, yeah.
Great. Samarth, I have a question. There's still a few people on. I'm
Oh, yeah.
wondering, since you've been a lawyer in India and you're now based in the Middle East in Dubai, I'm wondering if you've noticed some of any differences, or would you like to give us an example, or tell us some of the differences that you've seen in these two different styles and
Yes.
cultures?
Absolutely. So when I was at AZBO, when I was in India and working, perhaps there was some linguistic similarity. So I would see that the negotiation would move both in, and I was working in Delhi, so maybe it was because of that, English and Hindi. And so then when they were trying to get their way, they would speak in Hindi and kind of maybe be more polite. Now here, because we're working with multiple nationalities, it's a little more formal than that. So that's the first obvious thing, just simply because of the way things operate, way in a multinationality environment versus perhaps just everybody with the same linguistic background. That's one. But I have seen that yes. People do tend to be maybe more competitive. I have seen in the Indian space, because and I don't know if it's because of this region, everybody wanting to be just maybe people are more conflict averse here, and in India people are more like, okay, I need to do justice to this particular client, and or particular position that this client has advocated. So that's what I've seen, but it's just the experience of one person, so I don't want to extrapolate it to, oh, this is how people are. But what I have seen is, yes, these are the two things. One is the language is clearly very formal and very like perhaps like what you would have in an official setting, and in the other way it's more like, okay, yeah, this is the maybe more aggressive and more like, okay, I need to get what I have come in for. So I've seen more of that. Yeah. All right. Oh, I think you're on mute, maybe.
Oh,
Yeah.
right. Well, thank you everyone for coming. I hope that you enjoyed this first session with Samarth. I absolutely did, and I'm excited to have him next week also as our VIP guest drop-in sessions instructor for negotiation part 2, where you'll get some more interesting experience. I did not know that about the eye contact and the hierarchy in Ireland. And so there's some very interesting stuff here, and I'm sure it's going to be even more interesting next week. And then he'll be here. And if you have questions about LLM or applying for LLM, I encourage everybody to please gather those questions, and you can send Samarth an email directly, or go to his website at llmguru.com, is it?
Yeah, that's right.
llmguru.com. It's an easy one to remember. Other than that, I wish everybody a wonderful week, and look forward to seeing everybody next week, either in Jeff's session on Wednesday or Samarth's session on Friday. It's the exact same session on negotiation part 2, but quite a different style and different information. So excited to see everybody back. Have a great week, everyone.
All right. See you. See you, everyone.
All right, we'll catch up
Yes.
on another call, okay?
Okay. Yeah, absolutely. Okay. See you.